Before 1966, state and local law enforcement officers, as a matter of standard operating procedure, routinely interrogated suspects without informing them as to their right to remain silent under the Fifth Amendment and their right to counsel under the Sixth Amendment. In its decision, Miranda v. Arizona, the Supreme Court held this practice violated the requirements of the Constitution, and that statements made by suspects who have not been informed of their rights cannot be admitted as evidence at trial. Did this decision have the potential to substantially change the interrogation practices of law enforcement agencies? It undoubtedly did. In Plessy v. Ferguson, the Supreme Court upheld the state of Louisiana's requirement of separate but equal facilities. Did the court's decision have the potential to significantly change Louisiana's policy? No, it merely gave legal sanction of the highest court of the land to the policy that Louisiana was already implementing. Therefore, we must conclude that the Plessy decision does not satisfy our impact criterion and therefore cannot be an example of judicial policymaking. This is not to say that Plessy v. Ferguson is not a significant case. In fact, it is a critically important decision with respect to its legal ramifications. It had tremendous impact at law. But it does not qualify as a public policy decision because it doesn't have public policy impact. Return to the other cases that we outlined in the previous segments of this video lecture series and decide whether each satisfies the policy impact criterion. Ask yourself what the existing policy or practice was in each case. Then determine the extent to which the court's decision had the potential to change that policy.